outraged that she was smirking and laughing. But you're doing that now. Nobody allows $175 a month late fee. Well, we're actually fighting about 24 cents. Once you file a notice to quit, you can't accept any money. You've accepted November and December's rents. I can just dump it, make you start all over again. I'm going to blank your camera out.
Today, I have two prime examples of greedy landlords getting exactly what they deserve. Up first is this landlord who thinks she can smirk and laugh at the defendants on Zoom while charging predatory fees and rejecting rent payments, acting shocked when the tenants and the judge fight back. Then there's this lady. She wants her tenants out of there, but she just couldn't stop herself from happily taking their rent money. Judge Middleton has some bad news for both of them. Let's roll, nerds.
I want to address a little something before we begin. Your manager or owner, Ms. DeCenzo, is in the waiting room. I'll bring her in a minute. When she was here last time, I got an email from a viewer in November about how disrespectful and distracting she was at one of the previous hearings. And that particular person was outraged that she was smirking and laughing during the proceeding. And I thought I had forwarded that on to you, but I'm not sure that that was done. So anyway, we'll bring her in, and hopefully it isn't be an issue, or I can turn her camera off. But encourage me to play back the video. She's laughing and drinking water and making motions to other people, and that viewer felt she was very disrespectful. We'll see. I often don't have time to see what's going on on the screen. All right. This is file number 252403LT, Centerville Mobile Home Park versus Donna Speech. It was a demand for non-payment of rent. Meg Bauer filed an appearance on behalf of the, what do you need?
Is the bank able to speak right now?
She said she was going to have to wait.
Okay.
So I told her to just stay in the room, and then when Meg is, this may take us a while, but I told her. All right.
All right. Thank you.
We adjourned it. We've had several other cases with this part, and there are hidden costs that end up in the amount pled for that aren't often apparent. Ms. Bauer had applied for an ex parte escrow order, I believe was granted. Her claim is that the calculation for the amount due is not accurate. So let's start at the beginning. Mr. Landsman, what's the claim to rearage at this point?
Your Honor, for purposes of this hearing, my client is claiming the following. Lot rent of $1,320, which is $440 a month for October, November, and December. Late charges of $120 total based on this court's policy of capping late fees at $40 a month. A meter fee in the total amount of $25.50. That's $8.50 a month for 3 months. Total water and sewer of $155.26 for the 3 months. That's $51.17 December, $53.33 November, $50.76 October. An administrative fee of $15 being $5 a month. Mobile home tax of total $9 being $3 a month, and a line maintenance fee of $15.
Slow down.
Sorry, say when.
Mobile home tax, $9, 3 times 3. And what was the next?
And a line maintenance fee of $15, which is $5 a month for 3 months. That results in a grand total of $1,659.76, and court costs are $170.05 for a total of $1,829.81.
All right, well, let's try to parse this out. The defendant's contention, both in the previous case and this case, is that the plaintiff wouldn't accept payment without their, and nobody allows $175 a month late fee probably anywhere. And I think this is lot rent. There's a bunch of extra stuff in here which isn't in the lease, which are little things. The 850 times 3, the sewer is certainly this administrative fee of $5 a month, mobile home tax, line fee. I don't know if those things are in the lease or not, but those may also be issues. But it's in the billing. It shows mobile home tax, administrative fee, meter fee, lot rent. So they were aware of it. But so let's talk about what we're at right now, Ms. Bauer and Ms. Speech. Lot rent $440 per month, October, November, December. Are we in agreement with that?
Yes.
All right. Late fees, 3 months at $40 per month. Now, defendant may claim she's not late because she's tried to pay October or at least November and December, and the plaintiff wouldn't accept it. What's your response to the late fees, Ms. Bauer?
Miss Speech voluntarily or sua sponte attempted to pay a $50 late fee on October 17th on top of the balance that they claimed she owed, and that payment too was rejected as below minimum. So we object to anything in excess of $50 in late fees. I do also want to put in here we object to court costs because because she attempted to pay the entire balance through October plus a $50 late fee of her own that was prior to receiving advice from counsel on October 17th. And then subsequent to that, she attempted to pay all of the assessed charges, $440 in lot rent, the meter fee, admin fee, the tax, line maintenance fee. She attempted to pay all of that, plus the prior month, plus the $50 late fee on November 4th, which would not under the lease trigger any late fee provisions. So the only late fee that the defendant would consent to in order to seek resolution, perhaps, would be a late fee for October.
I can't tell from what I'm looking at how much I have in escrow. Maybe I can look in the electronic file. Can you tell me how many escrow payments you've made, Ms. Speech?
2.
So I have 886.
Judge,
I paid
you have
1,068 at first, and then I just paid December's before it was late, which was $514. So you have like 1,500 and something in escrow. 3 months.
1,068 was paid on November 21st, within a day or two of when the escrow order was entered, and then $512 on December 5th, according to the receipts I have, for a total of $1,580.
Where does that bring us?
That brings me,
All right, we'll see.
Looks
Mr.
like the
Lansford?
difference is $79.76, Your Honor.
And that would be the $240 late fees that we dispute. And of course, Ms. Speech would have no notice of this sort of random imposition or decision on the number for the late fees. So she would have no way to account for that. But again, she wasn't late. As soon as the escrow, she attempted to pay on November 4th. It was rejected by their lease pay system. So we asked for the escrow.
Just a minute. Mr.
Yes, yes.
Stenzo? Would you unmute your mic?
Hi, Your
I'm gonna blank your camera out. Viewers have contacted the court regarding your behavior on the screen. You're very animated about agreeing or disagreeing with what's going on. They felt you were very disrespectful to the court in the last hearing and were shocked that I didn't do anything about it. I wasn't paying attention. But you're doing that now. You're very animated with your approval or disapproval of what is being said. So I'm going to shut off your camera, but you'll be able to see us.
Understood.
And Your Honor, I will also jump in at this point and indicate to whichever viewer or viewers felt that shaking one's head is disrespectful, I am happy to take it up with those viewers directly, and they may feel free to contact my office, because I am completely and utterly opposed to their position.
Well, Judge, I would like to take a point to say that I have actually had repeated concerns about the respect that this park has treated to my clients during these hearings. And for example, when Ms. DeCenzo's colleague shared his screen with my client's personal information on the YouTube feed, without your consent and over my objection, it is not just the viewers that have been concerned. But I'm not here to make ad hominem attacks. I'm just here to get this resolved.
Yes. There we go. All right. She can hear us, but she can make all the gestures she wants and nobody can see it. All right. So we're getting close to where we need to be. So, Mr. Lansman, what's your response?
Your Honor, the tenant, firstly, I disagree with the court that, quote unquote, no judge would allow $175 in late fees. I could list several judges across this state that have allowed that or more. If this court chooses to, have its own cap, there are other courts that have done so.
Clear. Some judges allow no late fees.
That's true. Some others have caps based on whatever their reasoning is, and others allow late fees.
But I didn't know anybody was allowing one that big. But maybe so. You practice all over. I'm just here in Little Centerville. But yeah, the law on late fees, in fact, if you read it carefully, it doesn't even seem to allow it at all. But I've always allowed it, and I've let the number go up. But at any rate, fair enough.
And what I will say is that this tenant agreed to late fees of $175 in the lease. The lease is a contract. The words of a contract are to be given their clear meaning pursuant to Rory versus Continental Insurance, which is the landmark Michigan Supreme Court case in that area. As far as my client's rejection of the payment that was not a payment in full, if it had accepted that payment pursuant to Park Forest of Blackman versus Smith, Court of Appeals decision from, I believe, 1983, my client would arguably have been prevented from filing this case. So therefore, it was justified, in my opinion, based on the prevailing case law, as I understand it, it was entitled to reject the lesser payment. With that in mind, obviously, this court is entitled to make whatever ruling it wishes.
Let me stop you before you go forward. This isn't a termination of tenancy case. It's a non-payment of rent case.
That's right.
And Park Forest doesn't apply to non-payment of rent cases. It applies to termination of tenancy cases. So if you file a termination of tenancy, you're right. You're not supposed to accept any payment after that. If it's filed as a demand for non-payment of rent, the defendant is entitled to tender rent, and the plaintiff's supposed to accept it. But
I appreciate, Your Honor, this court's interpretation. Again, we practice all over the state, and other judges have taken a different position.
All right, Ms. Bauer.
Thank you, Judge. To address the Park Forest issue, it is inconsequential in this matter. Plaintiff's complaint is dated October 20th. However, Ms. Speech attempted to tender the entire balance due plus the late fees, a total of $563 on October 17th, 3 days prior to the filing of this complaint. So Park Forest, even under Mr. Landman's interpretation, wouldn't apply until a case had started, but she had attempted to make her payments prior to this case starting. So regardless of the interpretation, that issue doesn't hold water. She attempted to pay them everything she owed. They still rejected it because she did not attempt to pay them a $175 late fee. So let me turn to that issue.
Let me stop you right there. Mr. Landsman argues she signed a contract that said she agreed to pay $175 a month.
That's exactly
And
where I was
me or
going.
you or somebody else said, well, hey, now granted, they should have accepted whatever she tendered, but the lease says the late fee is $175 a month.
Judge, that was my next sentence. I said, so on that, to that point, a contract clause for late fees is a liquidated damages clause. It is supposed to be a reasonable estimate of the actual damages that are otherwise hard to calculate. That the breaching party occurs as a result of the non-breaching party occurs as a result of the breach, right? That's liquidated damages sort of 101. However, a liquidated damages clause is unenforceable if that clause is a penalty. If it is not intended to recover or account for actual and estimable damages actually incurred. So we have two issues here. And I'll say the defense's position is that, sure, that clause for $175 is in the contract, but it is a penalty and therefore is an invalid liquidated damages clause, and the court should not enforce it. I can provide a couple of citations, although Ramada Development Company versus United States Fidelity, and
Well, I'm not proposing to enforce it. So they, even under your client's position that they should have accepted her payment, it was not payment in full. If she unilaterally decides I don't have to pay the late fee, I hadn't made a ruling on the subject, the plaintiff still would have had a right to file this action, which they did, because there would have been at least some arrearage at that point, which so I would be inclined to allow the court costs.
the judge, by that argument, my client has to pay in order to defend herself.
Got her hand up. Mr. Senzo, you had a question?
Hi, Your Honor. Yes. I just want to apologize. I am a very animated person. And I promise you, it's not a sign of disrespect. More of a just upset that we're even here. We don't want to be here, and we respect your time. And we did not want to come to court today. So, in compliance with the last two rulings that you have given in this courtroom, we actually did change our late fees, whatever the term you want to call them, in efforts of trying to do right by you and your judgment. On the 20th of November, we actually sent a notice to our tenants letting them know that we were going to be actually obliging with your $40 late fee recommendations. And we sent a notice to Donna on the 20th of November, literally stating that we want to remain in compliance with your recommendations and that we were dropping the late fees to $40 for all tenants. And she still chose not to pay in December.
All right, thank you.
I'll state that at that point, the escrow order was already in place. And I do believe that had we not filed this motion in order request for ex parte order, this change would not have happened. We are glad to hear of this change. But I don't believe it would have happened had we not had to file. Or had we not filed?
May I speak?
Yeah, I let her speak.
On November 4th,
Now you have to speak up.
on November 4th, I did try to make my payment for November and October's with $50 late fee instead of a $40 late fee, and they locked me out. For 6
That is
weeks, I tried to
reflected in
make
my
my
notes.
payment.
Yeah, that's your attorney's already represented that.
So I just wanted to respond because she's saying November 20th. Well, how come you didn't let me pay it on November 4th then? And after that, it was done. The escrow order was in.
All right, we aren't very far apart.
So I let my lawyer do the rest, and they
Yes,
kept harassing
fair
me.
enough.
So
All right, so plaintiff's claim right now is for $1,659.76. And that's through December with a $40 late fee and the other related fees. Defendant has paid to this point into escrow $1,580, which is, as Mr. Landsman said, $79.76 apart. And as Ms. DeCenzo says, she didn't want to be here. I think it's unanimous. None of us wanted to be here, but here we are fighting about $79.76. But as Ms. Bauer said, these challenges have led the park to changing some policies and procedures, and they're new owners and they're learning our procedures. So maybe there's some benefit from this. The other issue is the filing fee of $170.05 that defendant objects to. And I didn't make a ruling, but I indicated my inclination is to allow the court costs. So that would be $79.76 minus $170.05. $249.81. I didn't even make a ruling. They just capitulated and agreed to move it to $40. I didn't make a court order or a court ruling. They just agreed to it. My opinion is they're entitled to their costs. We're going to set a second hearing, and you guys can think about it in the meantime, which would mean through December, the defendant would owe $1,659.76, offset by $1,580 that's presently in escrow, leaving a shortfall of $79.76.
Judge, you're intending to award them late fees for November and December, despite my clients paying within days of the escrow order and paying on the escrow order on December 5th?
because it's not late until after the 5th. And I was not late for November.
Yeah, that's a legitimate point. I don't want to fight about this anymore. I'm going to kick this can down the road. I resent spending an hour and a half to fight about $80, but we'll have to try to be accurate. Even it is a small amount. You're trying to make your point.
Attorney Landon could have called me also. This is the first I'm hearing of the concession.
The first I'm hearing of it as well.
All right. December 29th is quite full, but in for a penny, in for a pound.
I'm going to start using that at our case review decisions, Judge.
Yeah, well, yeah, that's the first day back after the holiday and the already crammed full of stuff. We're going to continue this. And again, every time we continue it, it's an additional cost to the plaintiff. Defendant doesn't pay cost for her services. Ms. Bauer argued that perhaps there should be an assessment of their costs. But maybe the parties can just agree, can agree to settle on a figure, in which case neither party would need to appear. But I'm going to continue this to 12, 29, 25 at 2:45. Yes?
Although we are a nonprofit law firm, we do still incur costs, and we're authorized by statute and by our regulations to request costs and fees. We just simply don't do that very often because it tends to harm our clients more than help.
Yes.
Your Honor,
I'm
they're
not-
only
I'm
entitled
not
to
insinuating
costs.
You didn't incur any costs, but your client didn't. Now, she's well represented here, and you're fortunate to have competent representation.
I'm very lucky, and I appreciate it.
As I indicated, they're new to this park, they're new to this business. They're well represented. Also, Jared Levine practices landlord tenant law all over the state. That law firm does. Mr. Landsman's been around, and he's done a good job for his clients in the past. And sometimes we need to fight it out a little bit to get to a place where everybody knows where to go moving forward. So I think we're getting there. We're fighting about not very much money. I would like to resolve this in December because I don't want to do another escrow payment in January.
Thank you.
I'd like you to just pay your rent to your landlord. But we're not very far apart. Ms. Bauer contends, perhaps with merit, there should not be a late fee for November or December because she attempted to tender the rent and the plaintiff wouldn't accept it. So in essence, we're fighting about $80. Well, we're actually fighting about 24 cents.
$40.
If I took the two late fees out, the arrearage would be a 4-cent credit. I would allow the attorney fees and the costs. So if I grant $80, you'd have a 4-cent credit toward January's rent, and I would allow the court costs of $170.05. So that's where we are. Not 4-cent, a 24-cent credit. We're going to address one more landlord tenant matter, then we're going to take our two general civil cases. Next is Walnut Meadows Apartments versus Susanna Hosteller, Ronaldo Austin. I have Anna Hosteller.
Yeah,
Are you
that's me.
here on that matter?
Yeah.
All right. Are you Susanna Hosteller?
Yeah, Anna's just my nickname.
Okay. Is Ronaldo there?
Yeah.
All right. He's sideways. You're all
Oh,
sideways.
Let's see if I can. Does that work better?
Yes.
Okay.
Mr. Thornton is here, and Judy, the manager, is also present. This is filed as a demand for non-payment of rent.
Your Honor, actually, it's a termination of tenants.
No, it is. Let me look at my note. There is no lease. It is filed as a termination of tenancy. Notice to quit was filed on October 20th. Mr. Thornton, what are the premises here?
An apartment at the Walnut Meadows facility. The lease expired in 2023. It was not renewed. So the tenants have been on a month-to-month tenancy.
Is this market rate or is this subsidized?
No, it's market rate to my knowledge.
Is that correct, Judy?
Yes.
All right, Ms. Hostetler and Mr. Austin, they can elect to continue with the tenancy month to month. Very often leases are for a year. When the year expires, then they just renew automatically month after month. In this case, they don't wish to have you as a tenant anymore, and they served a notice to quit in October, giving you until November to vacate. You didn't move, so they filed this action to get me to order you to move out. What's your position?
My position?
Yes.
First of all, my position is I asked her to let me sign a lease. I had my advocate contact her and said I needed help. She told me I could stay, that she would send me a new one. I have messages, pictures, everything on my phone of pictures of stuff they didn't fix, stuff they charged me for. They charged me for a bathtub that was over $800, and I paid my rent one time. I had money ordered from all the receipts that I paid and all that stuff. I offered to sign it. They said I could. I never got it. Got a mail. They did replace my mailbox key, but I lost it because it got lost in my purse, and I offered to pay for a new one, and they wouldn't give it to me, and they wouldn't come fix my stuff until my sister messaged them. Then they came down. They came down and fixed my fridge, and my advocate is actually here with me who can prove that. And they wouldn't fix my fridge. They wouldn't fix my key, give me a mailbox key, another mailbox key, even though I offered to pay for it. I offered to pay for damages, and I offered to pay for the rent if it went up. And I have an autistic child. I have a documented disability, and so does Ronaldo.
You have a disability and Ronaldo has a disability?
Yes, I have documents, and so does my daughter. And I have the documents on my phone to prove that. And I signed a paper saying my sister could speak for me, and we dropped it off, and they still wouldn't talk to her. And I signed it and have a video of me dropping it off.
So it's safe to say you don't want to move.
I don't. I have been looking, and I did get in contact with the place. I am just waiting for them to get authorization from their company. But this will take a few more days. It shouldn't take too much longer because I was in contact with them today and gave them. But I would like to stay at least until I can do that, because I've been sick recently and my daughter's been sick, and it's just, I've been working on it though, like a lot.
Everybody's been sick. All right. Well, Lance, what of all that? And Meg?
The Walnut Meadows position, Your Honor, is that Ms. Hostetler and Ms. Austin, in short, are problem tenants that create a lot of noise and a lot of issues for their surrounding tenants, to the point where Walnut Meadows is having tenants threaten to leave. That's in short, the reason for the non-renewal of the lease.
Because my daughter is autistic. But they're saying that it's because my daughter is filed because she's autistic.
All right. So it wasn't filed as a just cause termination, just expiration of the lease.
Correct.
All right.
Judge,
Ms. Hostetler, I got a view of your ceiling, I think.
Sorry.
All right. So they didn't file it as a demand for a just cause, but apparently they've got reason why they want you guys to move out. Now, you raised some issues which could constitute some defense to this. And you're also looking for another place to move to. I see that you're in outer space there.
No, I don't know how to move.
Well,
Okay, you got it. I got it.
we're on this planet. All right. Now, if you get evicted from here, it may make it very difficult for you to get in anywhere else.
Yeah.
Reason for leaving last apartment, evicted.
Yeah.
Perhaps there could be something else worked out if you find another place to move to.
Judge, I did hear the tenant indicate that she's paid her rent in full. So I would have some hardcore questions.
That's an issue that passed me by, Meg. Thanks for raising it. They served a notice to quit on October. So are you saying you've paid November and December's rent?
Yeah. I have the receipt. Where is it? Right here on this, right here.
Mr. Thornton, what do you know about that?
I just, last 2 days determined that and heard from Walnut Meadows that she did pay December's rent. Obviously, they will not be out until I've instructed Walnut Meadows not to take any further rent, and they will not be out by the end of December. So our position would be that we're not accepting any rent for January and would like
Well,
to proceed.
as you know, the Park Forest case says once you file a term tenancy, you can't accept any rent. And Ms. Bauer's theory would be the remedy would be dismissal and start all over again. It nullifies a termination of tenancy. And Judy, you should learn this. Once you file a notice to quit on a termination of tenancy, you can't accept any money. The acceptance of money, according to the case, is an indication that you're willing to continue the tenancy. So the notice to quit was filed in October, and in the meantime, you've accepted November and December's rent. So I can go a couple ways with this. I can just dump it and make you start all over again, or I can continue it and see where we are, but I don't think you're going to have the jurisdiction to go forward. Let's continue this.
Good afternoon, Your Honor.
Good afternoon.
I'm on Middleton Funding versus Clotis Weary.
Yes. Is that you, Mr. Sefton?
Yes, ma'am.
I think he's in another court. I'll put it back in the waiting room.
That's their attorney.
Ms. Hostetler, I'm going to let you speak to Ms. Bauer.
Okay.
Now, a couple things. Eventually, if they get what they ask for, they can probably compel you to move.
Okay.
So there's some problems with the way they've handled the case so far, but their intent is to get you to move, or other tenants are going to move out. And so the best solution would be if you could find another place to move to. But right now, you don't have to do anything because I haven't made any sort of ruling. We're going to
Okay.
revisit this.
Sorry, my nose hurts.
All right, Lance, how is Friday, January 2nd at 1:30?
That's open.
All right, now you have a market rate lease. It's not subsidized, but your claim is that you and your co-tenant and your son have a disability, which could affect their ability to do a termination without just cause. Then the next issue is they've accepted your rent, which may make this case terminal, and we may have to start over again. But let's see how you're doing between now and January 2nd in finding other housing. Ms. Bauer is here from Legal Aid if you wish to consult with her. Would you like to do that? Ms. Hostetler?
You say that one more time? Sorry.
Would you like to consult with the lawyer from Legal Aid?
Yeah, I have one that I've contacted. You mean this lawyer?
Yes, she's quite famous. She's here from Legal Aid.
Okay,
She's
okay.
all right. I'm going to put you in a breakout room with Ms. Bauer and let you discuss some of these issues. But Right
Okay.
now, I'm adjourning this case till Friday, January 2nd at 1:30.
Okay.
All right.
Judge, I see Ms. Hochsteller does have an intake with us, so I have her phone number.
All right. You already got an intake set up with legal aid, so just keep that appointment, okay?
Okay.
All right. You're good to go. I'll see you after Christmas on January 2nd.
All right. Thank you so much.